Honorable Judge of the Inter-American Human Rights, my name is Alejandro Chavez Rojas, and I appear today as the legal representative of the State of Mexico in the case Gonzalez Mendez versus Mexico. Before addressing our legal arguments, we want to reaffirm something essential. Mexico recognizes the gravity of every disappearance and proves suffering it causes to the families and communities. We acknowledge the pain experienced by the relatives of Mr. Antonio Gonzalez Mendez, who has been missing since January 18 of the 1999. At the same time, the state has an obligation to present the factual, legal, and evidentiary basis to guide its position before this court. The State of Mexico will respectfully argue five main points. Mexico has ratified all relevant Inter-American human rights instruments and has opened a follow-up investigation procedure in good faith. The evidence that record does not prove, under the state standards required by the court, the state agents caused that disappearance, not that Mexico acted with negligent omission equivalent to the international responsibility. The cases occurred in complex security environments, with the presence of armed non-state groups, which made investigations difficult. Even so, Mexico carried all numerous judicial forcing and administrative actions. Any shortcoming in early investigations were not to product of policy of tolerance of collusion. Mexico will show active cooperative attention to victims and legal reforms. The state respectfully asks the court apply regroups evidentiary standards to distinguish third-party criminality from the state action and the order only proportionate evidence-based measures. Mr. Antonio Mendez, a resident of Chiapas, was reported missing on January 18 of the 99. This period in Chiapas was marked by social and political tension, the presence of armed non-state groups, limited local government control in the certain rural zones, and outbreak of communal violence. According to the family's statements, Mr. Gonzalez Mendez left his home late at night and did not return. Local authorities were notified promptly and state immediately opening a criminal investigation. For Mexico, this disappearances has always been considered serious and urgent. This is a really matter of public interest. Mexico will prove the court with documentary proof extensive investigative efforts carried out from the 99 to the present to include inventory recording of the complaint and opening a criminal investigation, initial on-site inspection, witness interviews and evidence collection, forensic inquiries, grid search and request for technical support, coordination among municipal, state, federal authorities to supplement limited local capacities, collect of statements and documents including leading related possibly non-state armed groups. Mexico reminds the court that it's fully bounded by the American Convention of the Human Rights, the Inter-American Convention of Forced Disappearances of Persons, and the other human rights treaties. Domestically disappearance, kidnapping, and arbitrary detention are fully criminalized, and Mexico has built specialized investigation units, forensic institutions, national registries of missing persons, and strengthened the legal framework. This case should be assessed with Mexico long-term institutional evolution in responding to disappearance. The state will really base this on four pillars of evidence: the documentary evidence, the forensic expert testimony, the testimony of security context, the evidence of international reforms. Well, let's start with the legal arguments. The standard of proof. The Commission must prove on a credible basis that state conduct directly caused to disappearance or amounted to internationally wrongful omission. The evidence does not meet this standard. The second one, the non-state actors. The presence of armed groups does not automatically establish state collusion. International responsibility requires proof of state involvement, which is absent. Due diligence. Mexico opened investigations promptly to conduct research and gathered evidence and implemented reforms. While not perfect, this action takes meat that does not exceed diligence standard. The remedies. Mexico support remedies focus on truth, search continuation, technical support, and feasible reparation, but only those proportional the evidence. Mexico will present official investigations to this is the evidence and witness proposed by the state. Mexico will present official investigation files, prosecution and investigation, forensic experts, the security analysis, and the documentation of institutional reforms. This material shows that the state acted in good faith and with diligence. Honorable Judge, Mexico recognized the seriousness of this case, but seriousness alone does not establish state responsibility. We will demonstrate that Mexico opened investigations immediately, actively searched from Mr. Gonzalez Mendez, faced real and objective obstacles, do not state armed violence, and has strengthened institutions since the events of the 99. There is no evidence that Mexico State ordered, tolerated, or participated in the disappearance. The state respectfully requests the verdict grounded strictly this evidentiary record. Mexico position relies on a clear distinction between omission and commission, the requirements, causal connection, and the state conduct, and the commitment to proportional, feasible, and evidence-based remedies. The state also embraced cooperation, transparency, and forward-looking improvements. Well, Mexico stands before this court with humility and respect of the inter-American human rights system. We reaffirm our commitments to truth, justice, and non-repetition, but we also require that findings of responsibility be grounded by only in verifiable evidences and not in assumptions about complex historical context. Thank you, honorable judges, for your consideration.